Actually, of course, it's no longer news that the prosecution amended the former 7-count charge to 15-count charge, and we were served at the close of work day before yesterday. So when the matter came up yesterday, so we said that it cannot go on because Nnamdi Kanu needed to see the amended charge and advise, and we advised him on the plea to take. So the judge saw reason with us and adjourned the matter to today. Of course, we know that the matter has been adjourned acceleratedly. That is 18th, 19th, 20th. So as a result of that, as a result of late service and the filing of that amended charges, that of yesterday was truncated. So we are adjourned today. So when we came today, we saw the charge yesterday and we saw a reason by which we discovered that there is nothing before the judge. The charge is more or less empty. It's a replica of those charges that was struck out by my lord. They now only change some words, rechange the number and brought it in. So we said no, it cannot stand. And moreover, there is no proof of service served on us. So we said that you cannot proceed on this. So we filed notice of preliminary objection challenging the competence of the charge and the jurisdiction of my lord to hear the matter, and also filed his application for bail. Of course, everybody knows that Nnamdi Kanu never jumped bail. Rather, police invaded his house and wanted to kill him, so he had to run for his dear life because he's only a living that will stand for trial. But I will still come to that. So when we came today, when we came to court today, so the prosecution, Nnamdi Kanu now took his plea of not guilty on the 15 amended charges. So my lord now asked prosecution. Prosecution said that they are ready to go on. Go on with what? You have not served us with the proof of service, the proof of evidence. You have not served us anything, and we have no preliminary objection challenging the competency of the charge and the jurisdiction of the court. So we said, my lord, the Supreme Court have said in a plethora of cases that once a charge or the jurisdiction of the court or any motion is before the court, you must, no matter how stupid, that's the word the Supreme Court used, you must hear and determine that motion in one way or the other. So we decided a section, we said that my lord said, no, you cannot. I don't want to waste my time. I want to know, because we said that there is no charge. What are you trying? We said that there is no charge. The judge will first of all check whether there is a charge. So my lord now resolved that that they should respond to a notice of preliminary objection and give us 16th of this month by 1 p.m. to hear our notice of preliminary objection on the issue of bail. He said that that bail should not come up because if my lord upheld our notice of preliminary objection, then there is nothing before the court. Nnamdi Kanu will be discharged and acquitted. So, but based on the invasion of his house in Umuahia, this morning, Umuahia, Abia State High Court sitting in Umuahia has declared that action of federal government null and void and awarded cost of 1 billion naira in favor of Nnamdi Kanu against federal government. Somebody cannot be on bail. Somebody is on bail and you want to invade his house and you kill 28 persons and left with some cops. And you want the court to fold hands. If Nnamdi Kanu has violated his bail condition, you should have filed for court to set aside that is a bail condition and revoke his bail. What is the essence of using the military in the name of Operation Python now to go and kill, including innocent, including some little children that are still in orange? And the Federal High Court, Abia State High Court has done justice to that this morning.
We achieved a very commendable milestone today in court because the case has taken a different dimension, and a dimension which is encouraging in the circumstance. Of course, we are aware that this matter was scheduled yesterday for hearing of our objection to the charge and also to the jurisdiction of the court to hear the matter. 24 hours before yesterday, they filed an amended charge of 15 counts and served on us. So, which in effect truncated the proceedings of yesterday. And already, of course, you know, the 7-count amended charge they filed last year, we have an objection to that 7-count charge. So, which was scheduled to be heard on the 18th of this month, being yesterday, before they file another amended charge of 15-count charge. And we have already raised an objection to that charge. We raised an objection which was filed this morning and served on the prosecutor. So on the face of that objection, challenging the decision of the court, on the ground that the 15-count amended charge is as worthless as worthless paper as what one can never imagine. It has no basis, has no merit. So, and we address each and every of the counts in our objection. In an argument which I don't want to canvass, in the public domain here, is the fact that the 15-count charge is not strong enough to call our clients to stand trial. So the court will, in the circumstance, examine the objection to the charge, and which in effect is challenging the decision of the court to hear the matter. So, and determine on it one way or the other. If the court found merit in our application, The court will consequently dismiss the charge and acquit our client of the 15-count charge. This is what happened today. So the court have adjourned the matter to February 16th at 1 p.m. for the hearing of that application challenging the competency of the charge and also the decision of the court to hear the matter.